Good afternoon. Welcome to, it's March 11th. Welcome to hearings in House Economic Matters. We have a multitude of bills today. We're going to go out of order a little bit. So Delegate Frazier-Odago, we'll let you go first. I know you have another hearing coming up, so if we can get you out of the way.
Thank you, Mr. Chair, Vice Chair, members of the committee. Thank you for allowing me to present House Bill 1079. Most of you have heard a little bit about reconductoring, and essentially what this bill does is something that I know a lot of us, when we're making plans and moving forward on the grid, we need to better understand. Reconductoring, for those that don't know, is basically changing out current lines, looking at lines, electrical lines, temperature, putting in the newest, best technology that can move as much, in some cases, reportedly up to a 35% increase in electrical transfer. And what does that mean? That means if we do this right, then it means that we can look at transmission lines differently. We can look at power stations and building out power generation differently if we take into consideration increasing the ability for electricity to be transferred. For those, all this bill is a study. It has the Public Service Commission conduct a study on reconductoring. You heard from the Public Service Commission originally, and you heard from others as well that they, in general, I think they really like the concept of being able to study this. This could be very helpful for us moving forward in the future. It identifies reasonable, foreseeable future inadequacies in the electrical transmission grid. It identifies alternatives for building transmission lines, including grid-enhancing technologies having to do with temperature and a lot of other issues. There is a fiscal note to the bill. But that fiscal note was based on the Public Service Commission hiring a consultant to do the work. Some of the work they can do themselves, and some of them they're going to probably need a consultant to do. With that said, that fiscal note could be anywhere from $100,000 to $300,000 or $400,000. Depending. Right now the fiscal note sits at 300, but I suspect it can be done for far less, and I know that this is what they would like to do. So with that, I am happy to take questions on what reconductoring is and or what this study does. It reports back to us so that we can make better decisions moving forward for the ratepayer and the state of Maryland.
Phenomenal presentation. I see no questions. Thank you very much.
I was trying to be quick, Mr. Chair.
Sorry?
Thank you.
I mean, if you'd like, I know we have a bunch of bills, a bunch of witnesses. Oh, okay. Okay, thank you.
I'm happy to take it offline. Thank you.
Yep. Next we have is House Bill 1516, Delegate Queen. And Mr. Salazar, I believe you're here. If you could come up as well. What now?
Okay. All right, thank you, Mr. Chairman and Vice Chairman and members of the Economic Matters Committee. For the record, this is Delegate Pam Queen presenting HB 1516, Maryland Secondary Market Stabilization Act of 2025. So this is an emergency bill that is necessary to restore the stability for the secondary mortgage market in Maryland, and failure to pass this bill will risk continued disruption of our state's mortgage and other securitized loans and markets. So in April, why is this bill needed? In April of 2024, there was a legal decision in the state of Brown versus Ward that held that secondary mortgage market purchasers of loans, that's trust and other loan securitization vehicles, must have a license. And this is a action that has never been required here in Maryland or 49 other states. One state we know of Georgia, once tried this and had to revamp and stop that practice. So this emergency bill will restore our mortgage markets to the positions that it has existed prior to this Brown decision. And it exempts these licensures for these special purpose trusts that are used to facilitate facilitate the secondary mortgage market and other consumer loans. So just for background, because I know we hear a lot of terms, the secondary mortgage market has several important functions that it provides for us. So it provides liquidity to lenders to make new loans. So many of you are probably familiar with this, that you get a loan from a place and then Fannie Mae or Freddie Mac comes and buys that loan. They are providing funding to that bank so that they could go out and make new loans. So that helps us expand home ownership in communities, and it allows that bank not to have to carry that loan for the 25 or 30 years to its entirety. So it helps to reduce their risk. And so we need this market to be thriving to survive, and we need this market to be thriving, and so that our economy works well, especially in the housing market. Around 70% of all mortgages are typically held in secondary markets, with, as I alluded to, Fannie Mae and Freddie Mac being the larger holders of it. But here in Maryland, we have roughly 25 to 35% of Maryland loans that are held by outside of the Fannie Mae and Freddie Mac. So again, this bill is just putting into law the regulation that the Office of Financial Regulations put in place as a stopgap to make sure that the Brown versus Ward decision didn't disrupt our market. And so this is a bill that is supported by, of course, drafted by the Office of Financial Regulations, supported by the governor, and we really need to see that this takes place. I'm not going to read the whole testimony, but we have heard to date, I know people think it's hyperbole when we say that this will stop lending in the market, but the Office of Financial Regulations has already heard from various financial institutions to say that they will cease lending in Maryland, and I can give you the list of them, but it's over 9 or 10 of them so far that have made that declaration. And so we really do need to make sure that this bill passes to address that issue. So we ask for a favorable recommendation. I did want to mention that there have been, comments made by some of the opposition that talks about other issues like zombie loans and how do we deal with those things. This bill also proposes that we have a work group through the summer to address any sort of issues that may come out of what loans may have been made during this time frame and how do we address things going forward. But we do need to have this regulation codified to make sure that the case law that has set a precedent doesn't continue. Thank you. Anything else you want to add?
No, I think you've said it all. Yeah, we have seen, maybe I'll just add the one point that the delegate mentioned. We had seen an impact on the market. We've heard that others would also negatively act in the market if the bills aren't passed. I, can say from the perspective of the Office of the Commissioner, my viewpoint is that we have seen negative impact. It is likely if the bill does not pass, there will be some kind of negative impact on the market. I can't tell you the magnitude. I can't tell you exactly where, but that's why we came in and pushed this as an emergency bill, because we do believe that there will be a negative impact. Thank you.
Thank you very much. Seeing no question, that concludes this hearing. Next bill is House Bill 1455. I'm sorry? Right. Is Delegate McComas here? Is there anyone here from the Howard County delegation? Who? Delegate Fennell, would you like to go?
Thank you, Mr. Chair. Can I bring up my panel, please? Thank you. Mr. Chair and Vice Chair, For the record, I'm Delegate Diana Fennell. It is an honor for me to bring HB 1030 in reference to the deactivation of operators bill to this committee, to this esteemed committee of ECM. This information was brought to me by a constituent in my community from West Lanham Hills in reference to shared drivers being deactivated without just cause. So we've been meeting since the summertime in reference to this bill, in reference to trying to see about a process of 14 days that the PSC can be able to investigate and repeal any deactivation of drivers, because one of the things that was brought to me by Jeff, and you'll hear from him later on, is in reference to that it affects their livelihood, and also in reference to for them paying their bills, and then they don't have anywhere else to turn, and then they don't know why they're being deactivated. We also talked about in reference to, we do understand that when they do deactivate in reference to really a grievous cause, but we want to make sure that it's a just call and a due process. So I'm now going to turn it over to Mr. Yangston. Thank you.
Good afternoon, Chair, Vice Chair, and honorable members of the Economic Matters Committee. My name is Mitchell Yangston, and I am a part of the DMV Drivers Alliance. We're an organization made up of Uber and Lyft drivers throughout the state of Maryland, Virginia, and DC. I'm here today to endorse House Bill 1030, a bill that ensures transparency, fairness, and due process in the deactivation of rideshare drivers in Maryland. The rise of transportation network companies like Uber and Lyft offer convenience to riders and flexible work opportunities for drivers. Rideshare services are a vital source of income for thousands of Marylanders, allowing them to set their own hours and earn a living on their own terms. However, despite these benefits, a critical issue remains: the risk of sudden and often unjust deactivations due to drivers being classified as independent contractors rather than employees. Because of this classification, Uber and Lyft drivers lack traditional job protections, making them vulnerable to losing their livelihoods overnight, often without explanation or recourse. Many drivers invest thousands of dollars in vehicle maintenance, insurance, and fuel, and lives, only to be removed from the platform without notice, due process, or a path to appeal. Drivers from marginalized communities also face higher rates of deactivation due to unfair ratings, false complaints, and algorithmic bias. The process is so bad that there are Facebook posts that riders put up mentioning how they can get a free ride from their Uber and Lyft driver. This includes submitting false reports, verbal abuse, and so on. So despite relying on drivers' labor, Uber and Lyft offer no job security or due process, putting thousands at risk of losing their income overnight. HB 1030 seeks to address this issue by requiring rideshare companies to provide a written deactivation policy accessible to all drivers, advance notice before deactivation, except in cases of egregious misconduct, a fair appeals process to challenge unfair decisions. The bill does not prevent companies from removing unsafe drivers. Instead, it ensures the deactivations are justified, transparent, and fair. I urge the committee to please report favorably and vote for HB 1030. Thank you.
Thank you. Next.
Thank you, Chair and members of the committee. My name is Brian Wyville with Amalgamated Transit Union Local 689. We are here today because we are about 10 years into the gig work experiment. This General Assembly in 2015 took on the task of trying to set up a structure to regulate transportation network companies. We are about 10 years into this experiment, and we've seen some things that have gone well and other parts that need tweaking. At this point, I think it's fair to say that the assumptions that gig work would be supplemental work that someone would do in their spare time, that assumption was a little bit incorrect. At this point, we have data where many of our members that were deactivated are working 44 hours a week, 37 hours a week. These are not insubstantial losses of income. When someone is deactivated from a platform, they are losing their livelihood. So it is important that in the same way that when someone is deactivated or fired from a job in real W-2, W-4 employment, if someone is fired, there are protections in place in federal rules to make sure that that firing is not done in a discriminatory manner. So if those protections exist for those workers to protect their livelihood, we urge the committee to consider protections for these workers to make sure that deactivation policies are transparent, fair, and ultimately have the process of appeal that allow these workers to enforce their rights if the company's procedure is not being followed fairly. So I encourage the committee to issue a favorable report for this bill, and we will be back shortly to discuss other bills that might help the rideshare workers in protections for their industry.
Good afternoon, Chair, Vice Chair, and members of the rest of the ECM members. My name is Jeffrey Sweetland and have been an independent contractor since 2015 with Uber being my main source of income. In 2023, my Uber account was unfairly suspended and ultimately permanently deactivated due to a false accusation. I was falsely accused of sexual harassment. There was no police report, no evidence, no proof of any misconduct on my part, yet Uber chose to solely believe the customer instead of my word. At the time, I had a 4.92 rating and close to 15,000 trips. Customers on both Uber and Lyft know how to manipulate the system by falsely accusing drivers of anything for fare exchanges, refunds, free trips, etc. And these platforms will actually believe the customer instead of the driver. Drivers will have their accounts suspended or even permanently deactivated without Uber or Lyft even believing the driver to be innocent. Since both platforms have zero tolerance towards policies and safety towards discrimination, why is it that drivers of all walks of life are subjected to physical, verbal, and mental abuse by customers on these platform watches?
Thank you, Mr. Chairman. My name is Al Hassan Ibrahim. I live in Montgomery County in Gettysburg, precisely. I've been an Uber driver for the past 9 years and 7 months. My Uber app was deactivated last October after 27,132 rides. The reason that I have been unsafe driver. However, they did not give me any recourse to any appeal or anything to explain myself or whatever happened. I did not know. Secondly, there is a driver here sitting behind me who had just started driving for Uber after securing a car loan of $47,000. 3 months down the line, after everything, they deactivated him, telling him that he was involved in a prolonged ride fraud. Now he's saddled with a debt of $47,000 and a car loan of $1,000 per month. Mr. Chairman, the sad point is that when they do this, now you don't have anywhere to go and seek redress. We have to drive all the way to New York to Uber office to speak to somebody. There was nobody here in Maryland, Virginia, or DC who can be of help to you. And when we went to New York, either we couldn't get any help from there. HB 1030 will help us get a redress here in Maryland for Maryland drivers. Thank you very much.
And Mr. Chair, I ask for a favor review.
Any more questions? Thank you very much.
Thank you. Thank you.
Hi, thank you, Chair and members of the committee. My name's Frank Gaddy. I'm with the National Employment Law Project, or NELP. We're a national organization, nonprofit with 50 years of experience expanding worker protections on a federal, state, and local level. NELP works closely with allies in the so-called gig economy, and we are here today in support of HB 1030. NELP has filed written testimony, and I encourage you to review it. In the short time I have, I'm going to highlight the problem of unfair lockouts, suspensions and terminations, euphemistically called deactivations, and then explain why this bill is a necessary and common sense solution to that problem. So first of all, research indicates that a majority of rides are performed by full-time workers who depend on that money for their livelihoods. So when they get deactivated without notice or recourse, they struggle to make ends meet. Second, the deactivations have a greater impact on workers of color. Not only are Black and Latinx workers overrepresented in this work, but research suggests workers of color are deactivated at a higher rate than white workers. And then finally, deactivations are largely determined by hidden algorithms, leaving workers in the dark about why they've been deactivated with little notice or recourse to reverse that decision. HB 103 represents a common sense solution by setting up a fair process that will require a clear policy on deactivations that workers are informed of upfront, give workers the opportunity to respond before being locked out, suspended, or terminated, and allow workers to appeal their deactivation. Again, I hope you will consider NELP's longer written testimony, and I urge a favorable report on HB 1030. Thank you.
Thank you, Mr. Chairman. Question, the part of the bill is that they can't be deactivated. Is that what you're saying? Or they?
That they can't be deactivated? No, it sets up a process to stop unfair deactivations, though it is.
How do you define unfair deactivation?
Well, it's addressed in our written testimony, so I ask that you refer to the written testimony.
Okay, so you're not going to describe it. I'm just curious because my daughter took an Uber in Arlington, and the driver was incredibly creepy and asking really creepy personal questions. And so she had him drop her off at a nearby building instead of her building, after which time he, and the building fortunately let her in because it wasn't her building. And then the driver drove around like 4 or 5 times, stalking her. So would that be an unfair deactivation if she complained to Uber? I guess, I mean, the company has a responsibility, so it seems like.
Well, I think if there's legitimate concerns about things like sexual assault, that's covered.
Well, it wasn't an assault. It was just.
I understand.
Yeah.
But you also have to remember that most drivers don't know why they're deactivated. And so it could be a customer complains about, as some of the other drivers had described, that it could be that they just are claiming they're unsafe drivers. It's hard to really know. And so that's what we're trying to prevent, is these deactivations that happen with little notice and with little recourse to appeal those decisions.
And is it the purpose to unionize Uber? Is that the goal? Because it seems like there are a couple of unions before you and so forth. Is that the goal?
There's nothing in the bill about unionizing.
Got it. And it's just kind of interesting because when you see things like this and it seems very prescriptive, kind of ironic that we have Waymo outside today showcasing their car. And so it seems like an industry that is going to be obsolete anyway. So it's a lot of fighting over nothing, but thank you.
Thank you.
Thank you, Mr. Chairman. Just a question. When folks sign up, I guess, to drive for Uber or these other companies, do they describe, you don't have to get into super detail, but do they kind of go over a scenario in which you could be deactivated?
I'm actually not sure about that.
Okay. And then the second question would be, if you were to switch to a different company, do they ask if you've ever been deactivated by another company?
I'm not sure about that either.
Okay. Thank you, Mr. Chair.
Thank you.
So this bill is actually dealing with the due process and just process of deactivation, and I do believe, correct?
Yes.
Okay. And I do believe also that this bill is on Governor Youngkin's desk in Virginia?
Yes.
No? Yes. Okay, thank you.
Thank you.
I'm thinking, I guess, as we hear briefly, I guess my concern is twofold is, because we're at will state that there would be nothing stopping any of these rideshare companies from just terminating you and not giving a reason, because that's how Maryland is. And I say that because a lot of the things that we're discussing here are by contract employees. And it's my understanding that you guys are not employees at all, you're contractors. And ergo, you set your times, what you wear, when you show up, when you clock in, when you clock out. And the only thing that the company does, I guess, is facilitate your ride. So I guess I'm trying to figure out, number one, everything that was signed up, you're a contractor. And two, because of the way our structure is set up, it's more at will. And employees in the state, even if you have a job and then and you're a 1099, they don't have to tell you. They can just fire you. And I guess that's my concern here. And I think what Delegate Fisher was, kind of noticed was the union, involvement in something that is clearly you guys aren't even employees. And I know California tried to do something different. And their citizens said absolutely not. They did not allow, they did not change that standard. I know Maryland, I don't believe, is lining up to change that standard either. We have 3 parts to define the classification of an individual, and we believe that what your job is fits all 3 of those parts. You're a contractor. So again, while we look at this bill, I just want to make sure you understand the way things have currently been done through the state is you guys are contractors. And yeah, but we'll get to it. I'm sorry, we do have it was more of a statement, not a question. Apologize. I believe there's no other questions, so we'll go forward with amendments. We have one in person, Joe Brice.
He had to leave, Mr. Chairman. He was called. He's testifying in another hearing.
Well, thank you. Tell him his respect is.
I will definitely deliver that message.
I appreciate what other committee he found more important than being here. Please make sure you let him know that. Do we have any, do we have the, just unfavorable? Okay, so, and let him know now there are no favorable amendments. Joe should be proud. We'll move on to the unfavorables. Michelle Blackwell.
Good afternoon, Mr. Chairman, members of the Economic Matters Committee. My name is Michelle Blackwell, and I'm here on behalf of Uber. Thank you for giving me the opportunity to speak. Uber understands that losing the loss of an earning opportunity is one of the toughest moments for a driver, and the process of removing someone is not something that we take lightly. We don't deactivate a driver because we want to. We do it when we need to ensure safe and proper functioning of our platform. Despite its laudable goals, we have some concerns around some of the definitions. Just for time, I will just focus on one. For example, the term deactivation is simply defined as any restriction of a driver's access to the platform for more than 48 hours there's no exceptions or carve-outs. This doesn't contemplate when a driver loses access to the platform because of a missing and expired document that is required by the state or emergencies that are beyond everyone's control. This bill also doesn't consider the current safety and deactivation processes that we do have in place outside of egregious violations that require immediate removal before a driver is deactivated. We do alert the driver that their account is at risk. Drivers also do have a chance to provide additional information about what they think happened, along with any supporting evidence and media such as dash cam footage. While we believe the existing processes are fair and thorough, we actually do welcome a continued dialogue with the committee and would like to further discuss how we're striving to ensure that drivers have a fair experience. We would love to talk a little bit more about what it is that we are doing, but also where we can make improvements. I've spoken to some of these drivers here today, and so we are more than happy to sort of sit down and have that conversation. Thank you.
I just wanted to say that whether this bill succeeds or not, I do hope that you look to find out what solutions you guys can provide on your own. The government doesn't always have to step in. The companies can do right by their folks, and so I do appreciate and also ongoing conversation with the bill sponsor as well. Thank you, ma'am. I got you. Delegate Harrison, button was first. Go ahead.
Thank you. Good afternoon. I just want to follow up on a question that was asked earlier. When these individuals contract with you, do you, what is the process? What paperwork do they have to sign to understand that that they are a contractor, one, that there are certain requirements in terms they must meet, what could lead to a deactivation, and then how are you communicating with them if you find that you need to deactivate? Because there seems to be some discrepancy between what the drivers believe happens to them and what you're saying actually occurs.
So to answer your question in terms of information that's provided, so there is a terms and conditions agreement that once you are approved to come onto the platform, if you accept those terms and conditions, that sort of outlines what some of the conduct is. We also have our community guidelines, which are based in both law and just certain values and principles. And the community guidelines apply to everyone. That includes riders. I did have a chance to speak, again, like I said, with some of the drivers, and riders berating an individual is absolutely, that's just unacceptable. And so we have deactivated riders for that same purpose. And so I think that we probably could do some more in terms of communication, because there does seem to be a misunderstanding. I think there's a thinking that we don't have an appeal process, and there is one. We do try to notify drivers that their account is at risk if there has been a report. But that was why I said we are more than happy to sit down and talk with the committee and with drivers to figure out where there seems to be this disconnect and where we can work together. Because there are some definitions in the bill that are a little concerning in terms of safety and some requirements. There's a 14-day requirement before you can deactivate someone. If someone has committed, an egregious event, which, by the way, egregious misconduct is not fully defined, we might have to leave someone on the platform for nearly 2 weeks. So these are the types of things that we would just like to work with the sponsor and the committee on.
And finally, would you consider, if you don't already do it, sending those contract terms and agreements to your drivers on a regular basis, like, I don't know, annually, semi-annually, depending on how long the driver has been with you, so that it remains fresh in their minds?
Yeah, absolutely. And I will follow up with, I can follow up with you and the committee to see how often we do send that information out.
Doug Turner?
Right words of saying this, but I just want to make a statement. Okay, these drivers have rights, and a lot of their rights has been violated. I think they all need to form a union, and I'll help them.
I appreciate that, but I would ask that we don't advocate. We are lawmakers here. We are definitely not union opponents or proponents. And I understand, but while we're making a record for the public forever, that we understand that this body is not here to either thwart or support unions. It is everyone's right, if they can unionize, if they can first be considered, as other states have failed to do, an actual employee. It is not enough just to be at the person who mows my lawn may not be able to unionize because they're not my employee by any stretch of the imagination. And we have a definitive test in Maryland to determine whether someone is an employee or not. But I want to make it very clear for the record that there's no member of this body that is pro-union or anti-union. We are legislators, and that is our job. What we do on our other job, that may be a different story, and we respect what everybody does. But I just ask that we refrain from any of that publicly, because we are creating a record forever and ever. So, Delegate Johnson.
Thank you, Mr. Chair. Thank you for coming in today. So is there a difference between temporary and permanent deactivation, and could you explain that for me?
Yes, there is. So there is what would be like a temporary pause. So again, I mentioned sometimes it's just gathering documents. So for example, in Maryland, you do have to provide a driver's license. There are some drivers who have what are known as like a not for federal identification purposes driver's license. So we have to upload, the drivers have to upload that information. And sometimes there are delays in getting that information. Might be a vehicle registration issue. And so in those instances, because this body outlined the requirements for TNCs, we do have to do a temporary pause. A permanent pause is going to be something more along the lines of someone has committed an offense, assault, and so they have been removed from the platform due to safety purposes.
And for that, what's the review process, or how long does that review process take?
So the initial process is, I guess, if someone is accused of assault, they are notified. I believe their account is immediately paused, just given the allegation, and then they are allowed to respond. I can give you the timeframes. Sorry, I don't have them in front of me, but I can give you the timeframes. They're allowed to then upload any information. I had an instance in which, this does unfortunately happen, but there was like a rider who had claimed that they had. There was some sort of, interaction back and forth between the driver, but the driver had dash cam, right? And so they were able to sort of provide a little bit more context. I understand everybody does not have access to dash cam, but this is like one of the ways in which they can sort of dispute that. And then if it is then reviewed, and then once there's a determination that is made, we notify the drivers. There is an appeal process that's immediate within the app. And then there's another review process that goes there. Now, we are supposed to send them tips on how they can try to get reactivated after that.
All right, thank you very much.
So my question to you, back on the bill, my question to you in reference to the due and just process of 14 days, and I think we did address too, also in reference to dealing with grievance account, something severe to be automatically. But do you all share the information to the shared drivers in reference to why they was deactivated? Because that was one of the problems that we was addressing in reference to no one actually told them why they was deactivated. Do you all do that? Yes or no?
Mm-hmm. The agents are supposed to tell them why they are deactivated.
Thank you.
Thank you, Mr. Chairman. I had just a question that was mentioned, and I'm trying to go to your website to look at stuff. Because the person mentioned in one of the previous testimony, they didn't have anybody local to address issues with. And so on this website, I see where you have a place where you can meet your local employee resource group. Is that not available to folks who are contractors? Is there a difference between what I'm seeing on the website and what people get access to?
So I think what the driver was referring to is we used to have something called a green light hub. And so drivers could go to the green light hub if they had issues with their account. We no longer have those. And so drivers are allowed to do, or not allowed, drivers have access to a virtual green light hub. In terms of like the employee resource, we do have like driver advocacy groups for various regions. And so those groups should be available to drivers.
And that's a driver that's your employee versus a 1099?
No, everyone who drives on the platform is a 1099.
Everybody's a 1099, okay. All right, thank you.
Do you have one virtual? Margaret Durkin?
Good afternoon, Chair Wilson and members of the committee. My name is Margaret Durkin, and I'm the Mid-Atlantic Executive Director for TechNet, a tech trade association. Thank you for allowing me the opportunity to speak today on House Bill 1030. The sharing economy is creating a new source of income for people who want to work at their own discretion. TechNet is concerned about House Bill 1030 for several reasons. Our member companies take the safety of both riders and drivers extremely seriously and review each case to determine appropriate causes of action. Our members already have policies in place in terms of the appeals process and how it relates to operator deactivations. We are also concerned about the bill because we believe that it gives wide latitude to the Public Service Commission. For example, within the bill, there's the term reasonableness, which we think is extremely, again, giving wide latitude to them and leads to business uncertainty. As you can understand, businesses need certainty to operate, and we are concerned that the PSC having regulatory authority could lead to issues for our companies down the line. We're also concerned about this bill as it contains a private right of action. Thank you for your consideration of our concerns, and I'm happy to take any questions.
Seeing no questions, no more questions for this panel or this bill. That concludes this bill hearing. Thank you guys very much. We're going to move to Delegate Ahrens. Are you sure you're ready, Steve?
Yes, sir.
Thank you.
Commissioner, bring my panel up. Thank you. Good afternoon, members of the Economic Matters Committee, Chairman, Vice Chairman. For the record, my name is Delegate Steve Ahrens. I'm here to present House Bill 1455, Workers' Compensation, Average Weekly Wage, Multiple Employers. This is kind of an interesting bill for me. I'll go through a little bit of it here, but I was approached by a couple people about this bill and decided it was something I wanted to take up. The bill is concerning employment and accidental personal injury resulting in temporary partial disability or temporary total disability. Presently, the way our system works, a worker is injured on the job who is concurrently employed will receive workers' compensation only from the job which he was injured. This bill will require that the average weekly wages earned from concurrent employment be combined for the purpose of computing the average weekly wages. The bill will also require that an employer be reimbursed for certain compensation paid by the employer under certain circumstances from the subsequent injury fund or the uninsured employer's fund. In this economy, I think we're finding a whole lot of people have two jobs, and they're not always, well, when they do have an unfortunate incident, it's not always on their main job. Sometimes they're working 40 hours a week at a job, and that's the job that's really paying most of their bills, but they need subsequent income, so they go out and seek a second job. I was approached by a gentleman who was in exactly that situation, and he got hurt, and he's been unemployed and unable to be employed for several months. And what he was doing, he was able to collect that insurance off that lesser paying job. So he's literally lost 2/3 of his weekly salary. And when you put somebody in that position, they become desperate. I brought a gentleman along with me today to testify in a similar situation. And I would encourage you all to take a hard look at this bill. I know it's not a good bill that we always look at to draw more money from unemployment and workers' compensation, but it is something that's absolutely out there. It's something we're experiencing more and more in today's economy, where people are having to work two jobs, and should they be in the circumstance where they are hurt on that lesser job, we really put families at risk. I would encourage a favorable vote on this, and if I could ask, turn it over to Mike.
Good afternoon to all. My name is Thomas Hold it up. Okay. Sorry. Good afternoon to all. My name is Thomas Preslar, and 22 years ago, I was the victim of a domestic violence murder-suicide that occurred at my secondary part-time job. I was actually shot through the arm and back, and it took doctors over 7 hours to puzzle piece me back together. I was a completely innocent bystander that had no ties or involvement whatsoever to either party. And I was simply doing the responsible thing, trying to make a better life for my family by earning additional income. However, since I was shot while clocked in at my secondary job, which was just a basic gas station position, I wasn't legally permitted to claim any of the lost wages from my career job position as a carpenter building houses full-time due to Maryland's workers' comp laws. If it wasn't for those laws, I never would have gone through any of the financial hardships that I struggled through back then and that I still deal with today, 22 years later. Without claiming both sets of lost wages from the 2 jobs, I was only permitted to receive 80% of my part-time weekly income. That meant I went from making thousands of dollars each month, which was enough to cover all the rent, utilities, and household bills for myself and my young wife at the time, to making only $224 biweekly each month. After a year of dealing with my physical, emotional, and financial issues from the shooting, my wife couldn't take it anymore and she left. So after losing my marriage, my house, my cars, and even my ability to tie my shoes, I was forced to move back into my parents' house at the age of 23 with no hope or outlook for my future. After starting over from scratch with nothing, I was able to make a career for myself in the car business, simply because I can do it with one hand. My hope is to see that the Maryland workers' comp laws are corrected by allowing injured parties to the ability to claim all of their lost wages from every job that they currently have. Thank you for your time.
Delegate Queen.
Thank you. I just have a question if the sponsor knows. Do you know if any other states do what you're proposing in terms of, because I don't know a lot about
Yes, other states have it, but it's a different system that we can currently have. But there are other states that actually do this.
that allow
It's
you
like a
to buy?
stacking.
They do a stacking type
Correct.
approach. Okay, that's what I wanted. Thanks.
What was your last name, sir?
Preslar.
Okay, so, all right, thank you. That concludes this panel. So we're going to move on to the one-fifth of the minutes.
Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the Economic Matters Committee. My name is Jim Lanier, and I'm here on behalf of the Maryland Association for Justice. We're asking for a favorable report of HB 1455 with amendments. So, just like the gentleman said, this happens not often, but it does happen, and it does have a very impactful, not just on the injured worker, but on the injured worker's families. Like the gentleman who just spoke, I have a client who works as a welder Monday through Friday and drove a tractor trailer on the weekends. That was his hobby and he got paid for it. Got hurt in the tractor trailer job. His incomes are relatively the same, but he can only, because the injury was to his eye, so he can't do either job, but his wages and his benefits are only based upon one of the 2 jobs. So instead of earning somewhere close to the $1,300 combined, he gets about $450 in out-of-work benefits currently. To kind of address Delegate Queen, your question, the District of Columbia does have stacking, and some of the federal systems also for workers' comp do allow stacking. I believe Longshore, but I'm not 100% sure on that one. I know there are some federal systems. We actually do have something similar to what the Delegate Arnitz is proposing. It's more of a wage swap than it is a wage stack. In one part of the Workers' Comp Act, when you have a serious disability or a permanent total disability claim, you can take the higher of the 2, but the problem with that statute is very, very limited, and it doesn't help at the time in which the worker needs it the most, which is when they are not working. We determine permanency at the end of the claim, usually when they're better and back to work, unless they are permanently totally disabled. So it's more of a retroactive payment to allow them to get their money that they should have gotten years ago when they were out of work and recovery at the back end of the claim. Delegate Arnitz's bill would fix that problem because it would focus on the time in which they need the money the most when they're unable to work and they're in their recovery. We're requesting a favorable review with amendments. Thank you very much.
I was going to ask. So, sir, let me explain it to me. So, when you have a workers' comp, I apologize. We're just trying to figure it out. If somebody files, if one of my employees files a workers' comp claim against me, I know I can challenge it, right?
Of course.
And I can refute it, but it has a negative impact on me as an employer, right? Do my rates go up if there's a workers' comp claim against me?
I don't pretend to be an insurance person, but I know that, obviously if you have a successful claim filed against you, your rates can be readjusted, yes.
Right, and I guess that's the question on how this would work, because if I'm the full-time worker and my staff is working part-time, say security, and they collect, then as the full-time employer who actually pays him most of his salary, the greatest detriment would be placed on me.
But the power of the bill would be that you actually wouldn't be impacted because, number one, the employer and the insurer would pay, but then they would be reimbursed by, say, the subsequent injury fund, which is the way the statute works
And
now.
there's its own problem with a very insolvent fund, because we all understand the idea, just trying to find out how to make it work, because then we create even more insolvency in a fund, because as you said, the way the bill is, it doesn't necessarily go after a worker, or I mean employer, but we still have to figure out some way of keeping this fund full. I was just for my own, don't worry, it wasn't too much of a question, it was just for my own edification, was trying to understand, because I think everybody here understands the problem. We're just trying to figure out what the solution would be in a financial, in a way that doesn't punish, because I guess the other side of the coin would be, my concern was that, well, people would say, look, if you're working for me, you can only work for me. You can't work part-time, and you would be precluded, and the employers would start precluding their people from working any part-time job from Uber, Lyft, DoorDash, or anything for fear of being pulled into this. But that's kind of where we are.
Yes, sir. If I may, the subsequent injury fund, we do have the two state funds. The uninsured employers fund is mentioned in the bill, but it would go to whichever one had the higher balance, I believe is the way the bill writes it. And right now, it's not the UEF, but the SIF that pays the benefits under the Act now.
I see that.
Yes, sir.
And I guess the other thing would be how many claims are we talking about, Steve? Well, I'll get back with you.
Actually, I've asked that question a number of times, and nobody's been able to give you.
Yeah, because we're trying to figure out what kind of impact something like this would have.
Correct, and I've asked for that. But again, it's going to have to wait till somebody asks for it, other than me, but I've asked for it.
Okay. Now we have rules. Edgar Dodd and Ashley Smith and Michael Daly.
Mr. Chairman, Mr. Daly had to go for a family matter.
Yes, thank you. Good afternoon, Mr. Chair, Vice Chair, members of the House Economic Matters Committee. My name is Edgar Dodd. I am the Director of the Maryland Subsequent Injury Fund, and I am here to respectfully offer opposition testimony to this bill. The nobility of the bill is without question. However, my opposition is the Subsequent Injury Fund is not the vehicle by which to resolve these concerns. I've submitted written testimony in advance of this hearing, and I'm going to take my 2 minutes to touch on some of the highlights of the written testimony. The Subsequent Injury Fund is an independent Maryland state agency created to encourage the hiring and employment of Maryland workers with permanent pre-existing disabilities. And just give you an idea of our operation in FY 2024, our operating expenses were approximately $3 million. We paid approximately $18 million to severely injured Maryland workers, and our operating expense to benefit payment ratio is 17%. The two most important part of my testimony here today is under the current system, the Subsequent Injury Fund liability is limited to that portion of an injured worker's permanent disability that predates the accident. The SIF was not created, nor is the agency adequately funded to pay temporary partial or temporary total disability benefits. The bill also adds a new layer to the current system, and that is wage stacking. The introduction of these new SIF fiscal responsibility and temporary partial and temporary total disability claims will place unsustainable pressure on the Subsequent Injury Fund's ability to meet our future obligation benefit payments to permanently injured Maryland workers. It will also require an increase in funding revenue to make up the difference, and that's why I am testifying in opposition to the bill.
please.
Hello, Mr. Chair, Vice Chair, members of the committee. My name is Ashley Smith. I'm a member of the Maryland Defense Council. We are a group of attorneys who represent the interests of insurance companies, employers, and individuals who are sued in the state of Maryland, ranging from everything from commercial matters to workers' compensation. I'm here today to voice unfavorable sentiment to the bill on two primary points. The first of which is that this bill, as drafted, is unconstitutional in that it purports to retroactively apply higher benefits to existing claims. This has been addressed in the cases of Cooper versus Wycomico County Department of Public Works from 1976 and 1979, which state that retroactively increasing the amount of benefits owed by an employer and insurer, or I would assume a state agency, into the past is not constitutional. It would only be constitutional to the extent that it is forward-looking. And finally, this bill, as crafted, would take that additional payment from the SIF and the UEF. But just to build on something that the chair mentioned in his earlier comments, payroll for employers is used to calculate and forecast the potential future losses that an insurance company is insuring against. Without those wage information, it's really difficult to determine premiums, and that can result in increased premiums to employers and ultimately a burden to the insurance industry as a whole, if it were not to come from these funds. I understand that the way the bill is written, it comes from the funds currently, but if this were to be paid by the employers and insurers, it could have a real detrimental impact because there's just really no way to properly calculate premiums. And I think it could lead, as the chair indicated, to people trying to restrict part-time employment and things of that nature. And so for those reasons, we are unfavorable on this bill.
Just, you mentioned something that we can't go back.
Yes.
Would you be supportive of the bill if we could just start today and go forward?
I would not have as many objections to it going forward, assuming the funds stayed involved, because then it would not be coming out of the insurance company's pockets. Because as I mentioned, the issues with premiums, especially for small employers, would really be difficult. I wish that I could give you concrete information about the ways that it would increase premiums. Unfortunately, I don't have that data or that ability, but I do know that when you have uncertainty, they tend to go up to account for it. So while I agree with Mr. Dodd's position that the SIF and the UEF are not necessarily the correct parties to be paying this burden, the bill as written doesn't directly impact insurance companies. So the primary issue with the bill as written is its unconstitutionality.
From the part of going back?
Yes, that's correct.
I understand that. Mr. Dodd, just a couple for you. The funds that you have, do you know the balance offhand?
Yes, I do. Just give me a second. The balance at the end of FY 2024 was $130.6 million.
130.6. Is that combined?
That's our.
We'll look at the uninsured employers and also the subsequent injury. Do you know that?
I do not know. I have nothing to do with the uninsured employers fund.
And I don't know the answer to this question. Are all dollars paid for workman's comp, are they all allocated just to this fund?
No, the Workers' Compensation Commission passes an assessment in connection with every permanency and settlement award issued by the commission. 6.5% assessment goes to the subsequent injury fund, and 2% currently goes to the uninsured employers fund.
But all my workers' comp or comp fees all go to just those two things. Is that right?
No, there are others that get portions, if you will, but I can't testify as to what exactly they get. I can just tell you what the subsequent injury fund gets and what our current balance is. But it's important, if I may, we had an actuary study completed in 2022. It's going to be repeated this year, and the actuary projected that we have an unfunded liability for future payments of over $200 million. Now, that's alarming, However, that would be if the fund went out of business today. You know, our goal is to continue to be good stewards of the monies that have been entrusted to the subsequent injury fund to try to chip away at that unfunded liability.
And I appreciate we all want to be good stewards. I'm right there with you. And I typically am not the guy that brings these bills to the forefront. But this is a real problem. This isn't something I'm making up. This is a problem. And as your jobs involve it, what can we do to fix this? Because all we're saying is we don't care about you. We feel bad that you got hurt, but we really don't care because you know what? We just have not managed our money properly, and I'm sorry for your loss. Thank you very much, and I'll see you later. And I don't think that's acceptable to people that actually are out there working, because we wouldn't do that if it was permanent. We already healed the permanent, as I'm told. So I guess I'm asking, what else do you suggest for us to do? Because this falls on you all too, because this is part of your purview, not just mine.
Well, it's a very difficult question, Delegate, and I understand the seriousness of it. The subsequent injury fund was never created to pay temporary partial or temporary total disability benefits, and we've never been funded to pay those two benefits. We've always been involved in pre-existing serious disability cases, and I don't know what the solution is, but I can tell you that if pressure is placed on our balance, we're going to be obligated to come down here and tell the legislature and going to be going to the insurance companies for an increase in the assessment. And in my 10 years as director, that's something I committed never to have to do, and I truly don't want to have to do that.
Again, I want to thank you for all the help you've been. You've actually talked to me several times, and I appreciate our conversations.
No, we've had very cordial conversations.
I believe that's all the questions for this panel. Ms. Bill, is there enough? Delegate McComas. Ma'am, do you have a panel?
Yes, sir. I have Mr. Flax here with me.
Thank you.
He's actually the quarterback on this. I'm just a player. This is HB 1404, Rehabilitation Practitioners Certified Licensed Social Worker Clinical, also known as LCSWC. Under the Labor and Employment article, a rehabilitation practitioner currently means a nurse certified by the State Board of Nursing as a nurse case manager, a rehabilitation counselor, and a vocational evaluator. HB 1404 proposes to add a licensed certified social worker clinical to the list of potential providers for those obtaining a determination of benefits from the Maryland Workers' Compensation Commission. Not all injuries at work are physically apparent, but all services approved by the Workers' Compensation Commission should be available to the complainant. A simple change makes a significant difference in opening the door to more available services for those injured at work. To become a licensed certified social worker clinical, LCSWC, in Maryland, you need a CSWE accredited master's degree in social work, 3,000 hours of supervised clinical social work experience, and a passing score on the ASWB clinical exam. LCSWC licensees also have a continuing education requirement. These are highly trained providers in areas of mental and behavioral health. Just as HB 1404 provides for the addition of these professionals as rehabilitation practitioners, HB 1404 also states that violations of the rules and regulations adopted by the State Board of Social Work Examiners are grounds for denial or revocation of any applicant or registrant's registration as a rehabilitation practitioner. HB 1404 expands the services available to those injured at work through an award of benefits by the Workers' Compensation Commission. Please vote favorably for HB 1404. Thank you, Mr. Chair. Arthur, you got 2 minutes.
2 minutes. Arthur Flax, I recommend a favorable vote. This bill clarifies law. It doesn't expand practice. Presently, I'm registered with the Workers' Compensation Commission as a vocational rehabilitation counselor. G0235 is my number. It's based upon my education. I'm also under another section of the Labor and Employment Act. Clinical social workers are recognized to be paid for services to the Workers' Comp Commission. and so forth. So we are able to do this. But what the commission does is they list the name. They do not list your profession except for PT, for physical therapists, occupational therapists, and nurses. Everyone else is just listed by name. So a person who needs a service, particularly a mental health service is what I'm looking at, they don't know. All they see is Arthur Flax. They don't know what we do. So this bill clarifies the law. It doesn't expand practice, and it doesn't decrease it. It doesn't change anything that is not already in current law. It has to be about not having to be supervised in a certain area, and we don't have to be supervised in that area at the present time. The problem is it becomes confusing because under one section, if you look at it, 96A04, the subtitle does not limit the right of any individual to engage in a health occupation that the individual otherwise is authorized to engage in under the health occupations article. But if you go down to 96A09, then you had about supervision things. So the point is, this bill just clarifies the law. It makes it easy to identify a licensed certified social worker, clinical by profession, so that they can provide the services that the public needs. That's what I have to say.
You did a wonderful job, sir. I think you covered everything. I don't see any questions.
Mr. Chair, I would just say that we had an opportunity, to your great staff, to look at the testimony, and it seems like everybody agreed with us. So just want to say that I know from other bill hearings regarding the issue that we don't have enough people that can take care of folks that need experts. There's very few psychiatrists or psychologists that can deal with the mental health and emotional issues that go before the Workers' Compensation Commission. And I will just add, because I was familiar with this incident, a little boy was crushed in Bel Air, right on the main drag, and the officer that went to visit the little guy that was crushed by a trash truck, he had major problems. He'd had like 4 heart attacks, and he had psychological problems because of seeing the accident. And he was also a Vietnam vet. But, you know, so it was just kind of like a double whammy. So there are people that deal with really serious problems, whether they see something or they're a victim, they do have psychological issues to have to deal with, and that's what Mr. Flax can deal with. Yep. Or that we want to expand the universe of people that can take care of people that have, you know, emotional and behavioral issues due to a traumatic incident.
Yep. We definitely understand the purpose and meaning of the bill. That's no problem. Is your chief of staff supposed to testify today?
No, sir. This was just in case we had problems. Sure. Because quite honestly, we've had a lot of issues in our office this year.
No worries. But you just know if you can't ever show up, your chief of staff can always cover for you.
Okay. All right. Thank you, sir.
Is there James Lanier? Sir, if you want to come on up. Thank you guys very much.
Good afternoon again, Mr. Chair and members of the Economic Matters Committee. Again, my name is Jim Lanier. I'm here on behalf of Maryland Association for Justice. MAJ represents the injured workers of Maryland. So why does this bill help injured workers of Maryland? It does so in 2 ways. This bill would be impactful for what we call physical mental claims, where there's a physical injury that then develops into depression, anxiety, post-traumatic stress disorder, or you have a mental claim, you know, the armed robbery or the example that Delegate McComas had, where there's not a true physical injury, but someone develops something mental, you know, one of those diagnoses. So this bill can help in 2 areas of the workers' comp benefits to help Marylanders get better and back to work. On the medical recovery side, nurse case managers are mainly the people that help manage all of the medical needs that the injured worker needs to get better and back to work. And then the LCSWCs could also assist that with this bill for more of the mental injury parts. And when it comes to vocational services, the getting them back to work part, that's also where an LCSWC, with the inclusion of them in this bill, could also help with figuring out how to get a worker who could no longer return back to their pre-injury job for either physical, mental, or both, could help that person then get back to suitable gainful employment, which again, this bill affects both parts of the get the worker better and get the worker back to work. So we are asking for a favorable response or favorable report from this committee on this bill. Thank you very much.
Seeing no further questions on this bill. Thank you very much, sir.
Thank you, sir.
Moving on to the next bill. Is there anybody here from the Howard County delegation?
Yes, Mr. Chair, thank you.
Please.
Good afternoon, Chair Wilson, Vice Chair Crosby, committee members. For the record, I'm Delegate Jessica Feldmark, here on behalf of the Howard County delegation to present House Bill 1494. Several counties in Maryland already have authorization for a movie theater liquor license. These include Anne Arundel, Frederick, Hartford, Montgomery, Prince George's, and Washington. With House Bill 1494, our delegation is asking you to please add Howard County to that list. I will note the committee has received an amendment from the delegation. This is really just to clarify the county liquor board's authority in setting additional limits or requirements as they see fit. I ask respectfully for your favorable report, and I'm happy to answer any questions.
Seeing no questions, I believe that concludes this bill hearing.
Okay, thank you, Mr. Chairman.
Thank you. Now we have Delegate McCaskill. Is she here? There you are. Here on House Bill 1555.
Good afternoon, Mr. Chair, Mr. Vice Chair, and wonderful ECM Committee. Yes, this is my first time ever being in here. Hint, hint. For the record, I am For the record, I am Delegate Alethea McCaskill, representing District 44B, and I'm here to testify in support of House Bill 1551, which would increase the cap on how much of Class 5 breweries' taproom sales can be from beer that wasn't produced on site by Class 5 breweries. Currently, the law allows 25% of taproom sales to come from imported beer, and HB 1551 would increase the percentage to 35%. It would not change any of their limitations in the law that Class 5 brewery needs to comply with in order to sell imported beer in its tap room, including that the brand owner of the beer has to be affiliated with Class 5 brewery, and that the imported beer has to be purchased by Class 5 brewery from a licensed wholesaler in the state. The bill would also not change the overall cap in the amount of beer that could be sold in the tap room. I introduced this bill for Guinness Open Gate Brewery, a Class 5 brewery located in my district. Since opening 7 years ago, Open Gate Brewery has become one of Baltimore County's largest tourist attractions and has been a good community partner over these years. Open Gate Brewery is known for its unique craft beer it brews on site that are offered in its tap room, but it also offers the iconic Guinness Stout in the tap room and other beers that are only brewed in Guinness in Dublin, Ireland. Because these beers are not brewed on site, Open Gate Brewery imports them through a local Maryland distributor, and their sale in the tap room is subject to a cap with a Class 5 status. However, with increasing the popularity of Guinness in the market, it is becoming difficult for Open Stout Brewery to keep taproom sales of Guinness under the current limit. The current cap of 25% was put in place 8 years ago before Open Gate even opened. And House Bill 1551 simply asks for a modest update in the cap of 35% in order to align the customer's preferences. Please keep in mind, Mr. Chair, that Guinness contributes to many local communities, organizations, including the Food Bank and the Oyster Recovery Program, Partnership here in Maryland. This bill is not just business friendly, but it also is just good for our economy. So with that, Mr. Chair, I ask for a favorable report on HB 1551.
Just want to say thank you very much. I do have some concerns with the bill.
Yes.
And it really, and again, it's nothing that I think you need to address it. And I know, I appreciate the job you do for your district, and I understand. I guess I do have concerns with, you know, some of the issues that are being raised by this bill, and, you know, what we do for some, we must do for all. And the goals were really to have you, for when we opened this up, we wanted people to sell what they made. Because a lot of times you can sell, like a lot of the liquors that Guinness sells, I can buy most places, right? And so allowing them to sell at the brewery would make no difference. I could just buy it at the bar. So it really was to motivate Maryland brewers, and we obviously support Guinness, but to motivate Maryland brewers, you know, to sell stuff that they make in Maryland, not to become liquor stores or bars. So and these are just general concerns. You've done a wonderful job, and I always appreciate when people come in here and they fight hard for their constituencies. Very important. This is what we're here for. But I just wanted to, you know, up front, you know, some of the concerns, you don't have to address them. We'll address them. But I also don't like people just walking out of here thinking everything's hunky-dory if there's something. You know, I don't want you to be, you know, attacking my vice chair later because you thought this bill's going to pass. I'm joking.
Did
I know
he tell on me already?
He already did. He said you're a tough cookie, but but no, I just wanted to make sure you understood. I do have concerns. I will definitely speak with you later about them, but thank you very much. You've done a wonderful job.
I appreciate you. Thank you.
Next, we have House Bill, this is the Vaughn Stewart bill. This is going to be a minute. House Bill 861.
Back by popular demand, Mr. Chair.
By no one.
My panel can come up and join me, yeah. Mr. Chair, Mr. Vice Chair, honorable members of the Economic Matters Committee, Delegate Fisher, it's great to be with you today. My name is Vaughn Stewart. This is House Bill 861. So you already heard like a Lyft Uber worker bill. This is more of a Lyft Uber consumer protection bill. Essentially, there are two parts of the bill. The first part is, do we think that drivers should know how much, do we think that the drivers should know how much the customer paid for their ride? That allows them to essentially calculate the percentage that they got. So do we think that they deserve that information? The good news for the committee is everyone kind of agrees that drivers do deserve that information. So you're going to hear from Uber later that is cool with some kind of transparency to drivers about that issue. They're favorable with amendments. They're cool with that part. Virginia's already done something like this. Colorado's already done something like this. You won't hear from Lyft because presumably they're also cool with it. So everyone kind of agrees that drivers should probably know. Yeah. They'd be here, right? I mean, I can call them, but I don't know, I assume, right? They'd be mad. So, no, in all seriousness, the reason I think they're cool with it is because they've actually they're not fighting the other states. They've like actually implemented. There's a couple states that have passed this, and Uber has sued, and Lyft has just like done it. So I think Lyft is being kind of like the cool, the cool bro here, and like, good cop, bad cop. But anyway, Lyft, you won't hear from Lyft. Everyone seems to be mostly cool with like, okay, drivers should probably know the percentage that they're getting as an independent contractor versus the percentage of the company we get. The sticking point that the committee's going to have to figure out in the next couple of days, sorry about the late date, is whether or not riders should know how much of the money is going to the driver. That's really the sticking point. Is if you ride in Uber and Lyft, which I do all the time, I'm not anti-Uber Lyft. Do drivers deserve to know when they pay the percentage that goes to the driver? That's what you guys have to figure out. That's what people disagree about. Uber doesn't want the riders to have that information. You'll hear from them later. You'll hear from Ms. Durkin. And what I hope Ms. Durkin from TechNet answers is whether or not she also thinks that TechNet sounds a little bit like a 1998 internet browser, because that's what I think it sounds like. But what she'll probably tell you is that it's too burdensome for the rideshare companies to do this. So anyway, that's the bill. Like, everyone agrees, like, drivers should know. The question is, should riders know? I think riders should know, because I think they should be able to price shop. I think riders should be able to say, oh, I'm gonna either go Uber, Lyft, or some other third or fourth company based on the percentage that goes to the driver. I think riders deserve that information. That's for the committee to figure out. I urge a favorable report.
Good afternoon, Mr. Chair, Mr. Vice Chair, and of course, members of the Economic Matters Committee. My name is Mitchell, again, with the DMV Drivers Alliance, and I'm here to urge you to pass HB 0861, the Pay Transparency and Receipt Bill. When Uber and Lyft first started, the driver was able to see how much went to the customer and how much they got from the total fare. They can assess if they were being compensated fairly. Right now, in Virginia, Maryland, and DC, there is no rate card. There is no pay standard for an Uber and Lyft driver to look at to assess if they are being compensated fairly or not. Even independent contractors, traditional independent contractors, know what their rates are and can set their rates. Despite the legality of the status of Uber and Lyft drivers, they are not treated as independent contractors. They cannot negotiate with the passenger what the rate of the fare is going to be. They certainly cannot negotiate with a billion-dollar company what the rates are going to be. They cannot negotiate how much Uber and Lyft actually take from the fare and what fees are applied to the fare. So, and with the little information that the drivers have to scrounge up, the majority of each fare on any given ride goes to Uber and Lyft and the fees that they put on the ride. Again, these drivers cannot negotiate their pay rates. They're left in the dark to see what information that they could find to see if they're compensated fairly or not. And Uber and Lyft can take away those features at a drop of a dime. So for example, a couple years ago, Lyft did not provide any information to the drivers on how much their customer was charged. Uber took away the option of using the app to see how much the passenger was charged. So I urge the committee to please vote yes on HB 0861. Thank you.
Hello, everyone. Brian Wyville with Amalgamated Transit Union Local 689. To the points that were made previously, it is clear that in this situation, in this setup, the way transportation network companies have been designed as a marketplace, as a platform for workers and for customers and for the company to come together. Unfortunately, all parties except the companies are currently price takers. They do not have the ability to shop around because they do not necessarily know what those rates are going to be. These workers do not have the ability to decide what they are charging. They simply have to take the rate that is set by Uber or Lyft or by these rideshare companies. So with that in mind, the way that you actually allow these workers to be treated as independent contractors is with price transparency. It allows consumers to understand and vote with their dollars if they want to be using certain rideshare companies that have a better cut or more favorable cut for workers. It allows them to do that. And it also allows drivers to drive for companies that they believe has a better cut for drivers as well. So without this type of transparency in the way that the information is shared with the workers and the consumers, we won't be able to have the type of transportation network company system that everyone has been describing so far. Additionally, I would also like to stress the importance of the data provisions in this bill that allows for better information and understanding of the transportation network company industry in the future so that we have a better understanding how this state is actually operating its TNC system. And I urge a favorable report.
Good afternoon, Chair, Vice Chair, and the rest of the ECM members. Being a rideshare driver since 2015, we had two CEOs on Uber. We had Travis Kalanick, and then we have Dara Khosrowshahi currently. At one time, we had a base rate plus per mile plus per minute setup, including wait time. Now we are given what is known as upfront, where customers, let's say, could pay $30 for a trip and we could get $12 out of that trip. How fair is that to us when at one time we were supposed to be given 80% it was an 80-20% cut, which Uber and Lyft have severely shafted drivers since then. Furthermore, because of this setup, going back to an earlier bill, some drivers could be subjugated to verbal, mental, and physical abuse because of pricing, because there are customers who believe that we are getting the full price of a trip, whereas we are not.
Thanks, sir.
Okay. My name is Christopher Onyekwere, and I've been with Uber for more than 10 years now. And so I've been with Uber for more than 10 years.
Your name?
Christopher. Christopher Onyekwere. Okay.
You signed to testify, sir?
Yes.
Okay, go ahead.
What they're saying is true about transparency, because if Uber was like UPS or FedEx, or if they have the new Waymo truck, the Waymo vehicle will go to a place and come back, and there will be wear and tear, and there will be gas for both, going and coming, and for picking up at the same time. So the Uber driver, bears the cost of traffic jam, toll fees. Uber doesn't pay that. The customer doesn't pay that. Before, it used to be the customer that pays toll fees. So right now, the driver, bears the cost of the time, the toll, the false distance. Sometimes Uber gives us a distance, estimated distance, and when you put the actual GPS, it doubles, the mileage. And I think sometimes they do it deliberately to make more money for themselves. And if it is like going to Harrisburg, the distance is about 80 miles, Uber will pay you for about $44, and you're gonna go and come back, for the same price. So they are really sticking it to drivers. Drivers are the ones who are paying virtually, the cost of traffic jam, the cost of waiting for the customer. Waiting for the customer, sometimes you come to wait for your customer, and it will take like 5 minutes. And by the time the customer comes into the vehicle, Uber has already, the driver has already wasted time and everything, and gets paid only for $2.30. Before it used to be $5. So we, the drivers, bear the cost of virtually everything that Uber does right now, and that is very, very unfair. If Uber was a real transportation company, they don't know the cost of the gas it takes. Thank you.
All right, thank you. And I guess just for the baseline understanding here, as far as the way the rideshare network works, anybody can answer. Before you guys decide to take a passenger, where that passenger's got to be picked up from, and I'm assuming you know how much money you're going to make. Is that correct?
No.
So you pick up a passenger, you know where he wants to go.
They give you an estimate.
Estimate of what?
They give you estimate of the mileage.
Sure.
And the estimate is always wrong.
That's fine. That's fine. Because this bill doesn't change any of that. Right. I'm trying to get an understanding, a basic understanding of when you take a fare, the way it's laid out is you have no idea on a fare. If you picked up somebody here and you wanted to take them to DC, you would have no idea how much money you were going to make on that fare before you took it. Is that correct?
They give you an estimate.
No, that's what I want to find out. Do they give you a dollar estimate about how much money you're going to make?
Yes.
So before you take the fare, you kind of know how much money you're going to make on the fare. You can decide whether it's worth it or not, right? Go ahead, sir.
What makes the decision difficult is that you do not, after you complete the fare, they only give you an estimate of how much Uber takes from the fare and the fees that are applied.
But the fare goes to Uber, and they pay you out of the fare, correct?
Yes.
The fare.
There are fees that are attached to the fare, and the majority of those fees amount to the majority of the fare.
No.
The driver does not get the majority of the fare. They don't even get half of the fare.
This bill doesn't change any of that.
No, it doesn't. It doesn't. But you wouldn't know that information that I told you without the
sir,
transparency.
Please, let me run my committee and ask my questions.
Sorry,
I'm
sir.
not trying to corner you. I'm trying to get a basic understanding because I see where you're going. Just let me get there, okay? Because what I'm trying to understand is what position you're being put in, because I don't want anybody here to be confused. You do have a general idea if you're going to make money or not on a fare. They don't just tell you there's somebody outside and he wants to go to D.C. You're allowed to look at it and see approximately how much money you're going to make, right?
Right.
That's correct. Now, the passenger doesn't know. Fair?
Correct.
We have no idea how much money you're going to make on this trip. But
Correct.
the driver does have a rough estimate but how much money they're going to get back because we're paying Uber, not you.
Correct.
And they're going to, the agreement is they're going to give you back some of the fare, right?
Correct, Mr. Chair.
And is it usually, and this is important, he said it was a rough estimate. So I don't know why it would be an estimate. I'm trying to figure out why it's not more definitive. It's important.
That's correct, yeah.
And meaning that not even definitive, like, okay, well, this is as little it's going to be. If you get stuck in traffic or you have to go around and you put this many more miles on your car, of course, the fee will be higher, ergo, you will get more. But so it's not done by percentage, and I get all that. I just want, because I don't use Uber, so I really have no idea how this works. And so, but I do understand the basics is they give you an estimation on about how much you'll make on a trip to DC.
Correct.
Right. Now talk about, so in this bill, to be clear, doesn't change the upfront cost, the wear and tear, doesn't change if you're in traffic, doesn't change if you take the polls. What you're interested in is making sure that, number one, you know how much you're getting, which I assumed you already did, but you said not exactly. And two, that we know how much you're getting. So we may go, you know what, Lyft is paying its customers more, or its drivers more, so I'm going to go to Lyft.
Exactly.
You
got it. That's what the bill is a lot less ambitious than some of the descriptions you've heard here.
That's what I want to make sure, because
yes.
we drifted out in this wide cone. I want to narrow it back to what the bill does before, some of my people on the right start firing questions at you.
Appreciate that.
Let's go to, and speaking of people on the right, Delegate Pepe.
Delegate Pepe.
I got you next, Steve.
And when he means the right, he means the correct. So, yeah. So just elaborating, because I want to know, because I use Uber occasionally. I want to make sure I'm asking this correctly. So there are surge periods.
Yes.
Right. But as a driver, you are aware of what the multipliers are at any given time. Is that fair to say? So for example, if you go out on a Friday night, you know what the amount of money per mile is. You know what the fees are. Is there ever a scenario?
No, that isn't correct. No.
That's not true with drivers.
You see an estimate before you accept the trip, and even after you complete the trip, you see estimates of the fees that Uber takes out. They're still estimates. They're not real receipts that the driver gets.
So what do the fees usually cover? And just you go to the U with the.
So there are two types of fees that Uber and Lyft apply to the ride. There's their company fee that it says Uber fee or Lyft fee. And there's the external or additional fees that we do not know where those fees come from, nor is there a breakdown. They may argue well, these are maybe insurance estimates, but again, with insurance, you're always paying a fixed rate per month. These fluctuations in the external fees, we don't know what causes them. And we don't know if Uber and Lyft take a cut from those ambiguous external fees. It's that vague.
So and aside from whatever multiplier per mileage, or if there's a different day, like Friday nights are more important than like the middle of the week and stuff like that, but the fees also fluctuate throughout rides, and drivers are somewhat unaware of what those fluctuations are?
We don't know what causes them.
There is no state.
And
it's a quote, like, I'm going to go to DC, it's going to charge me $60,
Yeah.
no matter how much traffic there is, or how long the wait.
That's not what they're saying, though. They're saying it's You with me? Yeah, that's why I'm confused and intrigued, and I don't know if it's outside of this bill, and I apologize, because I'll just put it this way. So you guys, the main point of this bill, to get back to it, is that you want the customer to be able to see what percentage of whatever amounts collected goes to the driver, so the customer on some sort of morally high ground can determine which service they're going to use?
Yeah, hold on.
I mean, you know how to answer that.
Yeah, no, I'll answer it. I mean, that's basically right. I mean, I don't think it's a moral high ground. I just think that in general, consumers make decisions about where they shop for a bunch of different things.
Sure.
And for example, one other thing that's come up in my discussions with these folks is if you tip, right? I want to know if I have a great experience in a car and I'm deciding which percentage to tip.
Yeah.
I want to know, is my tip actually going to the person who gave me the great experience?
Does it go to the Uber executives or the driver? We have the bill for that. That's a different. We have a bill for that. All right, that's fine.
Good. You guys are on top of it.
So I'm going to wait until the Uber executive comes back about the just my own thing.
Totally. And I think that larger point here is the reason there's a little bit of confusion about this fee, that fee, what time, whatever, is that this whole industry is fairly, there's not a whole lot of transparency just generally. It's an opaque arrangement. They use algorithmic pricing and all this AI stuff, which is fine. That's awesome that they do. And they use all sorts of surge things that they keep tight to their vest. I know a lot of it is trade secrets and IP, and I totally understand that. That's why we didn't go super big or super ambitious with this bill. We're just asking for one thing everyone's cool with was let the drivers know what the percentage is, and the one weird thing that I'm asking that Uber I think is not going to like as much is let's let the customers know as well. That's it.
Okay, thank you.
Okay, thank you. Sorry about the confusion. I guess my biggest question comes in to this is that I understand what you want. I don't understand why, because I know if I go on the metro, I don't have to tell who gets what. I don't know, I'm not tipping anybody, but I'm paying for it, certainly. And it's not a tipped job. So give me a better reason why you think I need to know the difference.
Yeah, totally.
As the customer.
Well, I think it's a little bit different on the Metro because that's a monopoly service, right? I can't think of too many examples where I have two companies I can choose from, and I'm provided less information about where my dollars are going.
Okay. Do I get that with a taxi cab? Do I get that same response with a taxi cab?
I think for a taxi cab, if it's like a medallion driver in a city with a medallion system, you can ask them the share that goes to them versus the share that goes to the company, and they'll reliably be able to tell you that figure because they're told.
So
you don't necessarily.
I'll give you an idea, which you could do right now. You all could do what goes to. You know what you're getting paid.
No, the drivers don't know. That's the point of the bill is that we're trying to tell the drivers and the passengers. The passengers can't ask the drivers in the Ubers or Lyft because they don't know either.
Actually, I think you cleared that up earlier on a question. He said, do you know how much roughly what you're going to get paid on that job?
Yeah, so that's true.
So you know roughly what you're going to get paid. You know roughly what you're getting out of that. Am I correct? So roughly you could do that.
Yes, yeah. So the driver and the passenger, if they wanted to put their heads together and do some math, they could, and that occasionally does happen.
That's the same thing. The taxi cab driver, he could roughly tell you that. He'll give you something close. Exactly.
Sure, I suppose, right? But the point of the bill is that there are two big companies in the marketplace. We don't think that one of them should be able to get a market advantage by providing extra transparency to customers over the other big company. And we think that customers should be able to vote with their feet on a number of different things, but including the extent to which the companies are compensating the drivers for their work. And like I mentioned before, I think this is a better, if you don't like that rationale, I'm with you. I think the better rationale, and to me what honestly motivated me to put in the bill more than anything is, if you tip a cab driver with cash, which you can do because you can still pay with a cash or card, you know where your tip is going. You're giving him a 20 on the way out. You know that cab driver is pocketing the money. You cannot do that with Uber and Lyft. You can tip them on the app, but unlike basically any other tip that I can think of, you don't know if the tip is going to them 100%, 0%, or 50%.
I think that's another bill, but I agree with that. But even in a restaurant, delegate, with all due respect, I have tipped servers. Everybody's tipped. I don't know that I'd ever provide. Nobody's ever asked me, well, let me go back to my table and tell them just how much out of this $250 tab is going to your pocket versus or to the house and versus to me.
I'll let this gentleman answer. That's okay. It seems like he wants to hop in.
Sir, at least you know the exact rate that the waiter is paid, even a base rate. There is no base rate for the gig driver. So that's why the analogy is troublesome, because even with tipped workers, you at least know that they're going to be paid a base rate. There is no base rate for gig drivers.
Well, I would argue that just because I think you're upfront of what you're going to get paid. You know you're going to get something to do that trip, as we established. But
It's only estimates, sir, but
okay, I get you. Thank you.
Thank you, Mr. Chairman. I just have a question. I agree with the understanding that the drivers need to know what they get paid, and that makes sense to me. I'll just tell you from my experience, and I kind of do use Uber and Lyft quite often because I don't like driving into the city, and whenever I travel, I don't like driving with cars. Because I had a rental car vandalized. I don't like driving. So anyway.
I'm with you.
So, and I just used one this past weekend. But the way I price compare is, like I'm at the airport and I say, how much it gets me to go to my hotel. I put it in Uber. They'll have it'll be this rate if I want to do it in 2 minutes or 6 minutes, or if I want this deluxe car, it's another thing. Then I go and put it in to Lyft.
Yeah.
And then I decide, okay, which one was cheaper, right? That's it. That's my price comparison.
Right.
And then both apps, I believe, allow me to tip, and I think they both come back and say 100% went to the driver. Now, I don't know if they're lying or not, but they come back and tell me, thank you for your tip. And, and sometimes the driver will respond back, thank you for the tip as well. So I think they are getting their tips. I don't know. I think they're getting 100%. But the idea that I would, as a consumer, really want to know that breakout of what they're paid versus what the fee I'm paying, I think is less of concern to me. I'm gonna look at that total price I'm paying for that trip, and then use that. The only other thing, and I think maybe this is why they may not tell them everything up front. This last time I did, this last trip I did, I had Lyft was cheaper, so I was using Lyft. And then while I was waiting for the driver, they switched drivers out on me. And it's like, this driver can get there sooner. The time frame was good. And this other driver had a Tesla. So I was kind of like happy. I got to ride in a Tesla the first time in my life from a Lyft drive. So I was happy with that. I didn't have to pay anything different, and I got where I wanted to go. So I don't see why I would need to know that. That's all.
I would say, I appreciate the question. So consumers have different preferences. Not all consumers are going to choose different things for the same reasons. And what I would say is, just speaking from my own experience, is if I also did the exact same thing you did. I'm looking at what's the price and what's the car and who's going to get there quickest, right? But if I have a comparison between, because oftentimes the prices are similar. If I have a comparison between $35 for an Uber, $32 for a Lyft, similar cars, similar times, but then Lyft tells me that 90% is going to go to the driver. And Uber tells me that, now I'm not saying these are real numbers, but Uber tells me that 40% is going to the driver. I can't say that would always cause me to choose the Lyft, that information, because maybe depending on if I'm in a hurry or not, to Delegate Pippy's point, maybe I don't feel like being a do-gooder that day to the workers of these companies. I don't know what my mood is going to be, but I certainly would prefer to live in that world where I, as a consumer, at least have that additional information and I can have one more type of choice to make. But again, I think there are probably consumers that are different than you and I, Delegate Queen, who for them that would be their number one focus, would be what the workers get. For me, it may be 2 or 3. For you, it may be 4 or 5. But I think Marylanders who would like to shop based on this deserve that opportunity.
We understand that you're signaling that you live on the moral high ground.
I was putting myself in the median of the high ground, right? Like
gotcha,
mid-ground, yeah.
I don't see any more questions for this panel. Thank you very much. I do believe we have Jeffrey Sweetland, you already testified, okay, and Alasan Mohammed Ibrahim.
Yes, sir.
And go ahead, sir.
Thank you very much, Mr. Chairman. I was listening to some of the questions, and I would like to clarify some of the answers. The problem with Uber and Lyft, as a driver who has been on this platform for the past 9.5 years, when we started driving, you know that Uber is taking 35%, you are getting 65%. And before, there was no tip at all. And gradually, we complained, and they introduced tips. And now, most of the riders that I pick up, they complain that Uber and Lyft are trying to supplement our income with the tips because they are not paying as fairly as it's supposed to be. Imagine you have a ride that the rider pays $77 and Uber or Lyft gives you $17. And estimated insurance is $39. The rest goes to the fee. Insurance is not actual, it's estimate. So if at the end of the month or the year, if you pay less on the insurance, where would the rest of the $39 be? That is the problem with the drivers. So, I mean, gradually, what I can say is that we are kind of tip employees misclassified as independent contractors. That is what is coming to with Uber and Lyft platform for the 9 years coming, like since inception over a decade now. That is how the move is on the platforms. Thank you.
I believe we have, thank you very much, sir. Now we move on to favorite members there. Michelle Blackwell.
Thank you.
Good afternoon again. Michelle Blackwell on behalf of Uber. I think we all agree that transparency is important. Unless there have been amendments to this bill, I think what we're talking about is what riders and drivers see at the conclusion of a trip, which is on the receipt. And so as I submitted in my testimony, there's already a lot of information that's on the receipts right now that we do currently provide. Just a quick walkthrough, the amount that a rider paid for the trip is what HB 861 is proposing. We already do put on the driver receipt the amount that a rider paid for the trip. It's the same thing in terms of what the driver will receive. 861 is saying that that needs to be on the driver receipt. It does mention on our driver receipt currently the amount the driver will receive from the trip. And then 861 proposes the final amount of any additional fees that are charged to the rider, which is also shared with the drivers. Additionally, as I think was mentioned, Uber service fee is also included on the driver receipt, plus the amount that was tipped by the rider. On the rider side, it's very similar. And again, I've shared my testimony with the committee. I will say, given all of the conversations around transparency, we think there's a better way to do this, which is the Virginia model. Virginia looks at this holistically. I think there is a concern about doing this on a piece by piece basis, given the fact that it does not actually give the drivers like a whole view of what they are going to see at the end of the week. And so we are proposing that this committee, if it would like to go forward, to use the Virginia model. I know there are a lot of questions, so I will end there, but we do support, but with these amendments.
Go ahead, sir.
Yes, hello. Once again, I'm Frank Gaddy with the National Employment Law Project, known as NELP. We advocate for workers on a federal, state, and local level, and I'm here today in support of HB 861 with amendments. We've also filed written testimony, so I encourage you to review that. Today, I'm just going to talk a little bit about how the lack of transparency affects working conditions, and then how some amendments to this bill could make it more meaningful. So one, app corporations like Uber and Lyft collect data on drivers and passengers and feed that into hidden algorithms that determine things like what rides a driver will be assigned, how much they'll be paid, and then if they are terminated, also known as deactivated. Second, also while they tout their flexibility, research has found that companies often use gamification to manipulate workers' behavior, making it impossible for them to plan their shifts and how long they'll be working. HB 861 is a good step towards transparency, but we do recommend a couple amendments. First, we recommend bringing the bill in line with the law recently enacted in Colorado. That law just requires companies to give a lot more detailed information, and you can find that in our written testimony. And then second, we recommend amending it to include data disclosure requirements as well as use and accessibility requirements, including companies to release public data reports in accessible formats. So for example, those can be accessed by researchers who can look at that data as well. Again, I hope you'll consider our longer written testimony, and we urge a favorable report on 861 with amendments. Thank you.
Ma'am, did you reach out to the bill sponsor to talk about, because we're clearly now we're on to two different models, the VA model and the gentleman said a Colorado bill. Have you spoken with the sponsor of this bill?
I have not.
Okay, he's fairly difficult to deal with, so good luck. But no, I would ask that you do that, because I think honestly it doesn't sound like you guys are overtly opposed to what they're trying to do. And whether you agree with, choice or not, I'm going to say it that way, but, there are some people that may want to choose, a business that they feel pays their employees more, or in this case, their contractors more. So I don't see the problem. Again, we have a very short time. Is this a cross file?
There is cross file.
Please don't say it's Senator Kramer.
Unfortunately, it's Senator Kramer.
Probably no need to keep going. I think we buried this one in the ditch. Well, in spite of that, I would ask, especially because when he comes over here, we're just going to get 45 minutes of yelling. So if we could, that would be wonderful. But if we could get this resolved, I do believe this is an issue we can actually resolve. So please, I will hope that both of you decide to work with the bill sponsor to see if there's something we can do successful. I know it's a short amount of time, but this is important. We do have one question, Delegate Harrison.
Yeah, I just wanted to ask one thing, because I'm looking at an old receipt of mine, Uber, and it lists all of the fees. Do you not provide something like that to your drivers at the end of the day, week, month, whatever, so that they would know and they can see what the fees are?
Yes, at the end of each trip, they do see what the rider paid, what we took, what state mandated fees, additional fees such as insurance. I know that was mentioned earlier. We are one of the largest carriers of auto insurance in the country, and it is quite expensive. And so that there is cost that's associated with that. So that is taken out. And so they do get a detailed receipt at the end of each trip.
Okay, thank you, because I have a detailed receipt here. Of course, mine would be different than what theirs would be, but thank you.
If I may, Mr. Chair, just respond to one point that you raised.
Not normally, but go ahead.
Oh, thank you. I know there's been a lot of conversation around what riders can see. I don't think that this has been raised, at least not through this discussion, but there is a privacy concern. I'm not sure that every single driver necessarily wants a rider to know how much they are earning on a trip. That's one. Two, I will say, and I think the drivers, the panel that was before me is a perfect example of this, is that drivers are very honest. If you talk to your driver and ask them, they will let you know. The concern we have is this is a snapshot in time. It does not give the overall picture of what drivers are actually earning, and what we are taking. And so I failed to mention that, and I'd like to say that.
I guess kind of an opt-out for the driver, if you think privacy is an issue, I guess there's an opt-out for letting you work in. Now, one of the, you did bring this up. You guys.
Turn your mic on, Mr. Chair. Please, thank you.
Y'all heard me. Thank you. Now, do you guys provide your own insurance, correct?
Yes, we do. Well, so each trip is done through what we call periods. So the first period where drivers are just waiting for a trip, they're driving around, their insurance is in effect. And then once a rider, we call this P2, once they accept a trip, and then they take the rider on that trip through P3, our insurance is what covers.
Yeah, so they have to be insured, but during their actual, working as a contractor for you, the actual work, they're insured under your insurance.
Yes, through P2 and P3. That's correct.
Got you. Well, again, I do hope you guys try to, That was my bad. I drugged this out. Delegate Fisher.
No. So, did you say that the drivers, I'm so confused because I've heard different things. The drivers do or do not receive what they do not know what they're going to make on a trip in advance?
They do. They have what's known as an offer card. I think the gentleman mentioned it is an estimate. Part of the reason why it's an estimate is because there are various things that can happen. I think the same gentleman had mentioned, like wait times. If if you have a driver waiting for 5 minutes or more, we do compensate them for that. I know there's conversations and concerns about what that compensation is, but they are compensated for that. Additionally, if a rider decides that they want to change where they're going, that might also impact their fare. I don't know if you guys have ever been on trip. I've done this where I'm in the vehicle, I decide that I need to make an adjustment. I am told that the trip might be at a different price. So there are various factors, which is why it is an estimate.
Mm-hmm. And they're also charged insurance through Uber?
No, we cover the insurance through periods 2 and period 3.
Mm-hmm.
Like our insurance policies are in effect.
So it's a rider insurance over their insurance policy? Is that what you're saying?
Yes. So if something happens in the vehicle, there's $1 million liability policy. Right. So if something happens with the driver, those who are impacted by the accident are covered by up to $1 million.
Got it. Thanks.
And have we done our online? All right, we have one more, Ms. Durkin. Go ahead, ma'am.
Good afternoon again, Chair Wilson and members of the committee. My name is Margaret Durkin. I'm from TechNet, or as the sponsor referred to us as the 90s tech browser, here to speak today on House Bill 861. I did send my written remarks to the sponsor, and I'm in the process of gathering some information from members to see if we can come to a consensus on this. But largely our concerns remain the same with prior speakers. Our TNC members work under a competitive marketplace, both for riders and drivers. And independent contractors maintain the right to choose a ride if they wish to, or decline a ride based on the estimate. And our member partners do provide that information to our drivers. And as an example, one of our members does have a 70% earnings guarantee for their drivers, for those consumers that are concerned about what type of service they are paying for and where they want their money to go. So one of our members does have that earnings guarantee. We're concerned again here that this bill gives wide latitude to the Public Service Commission, specifically provisions. They shall determine the form and content of the demographic data received. Again, businesses need certainty to thrive, and we are concerned that this will lead to business uncertainty. Again, happy to continue conversations with the sponsor, and I'm here to take any questions. Thank you.
Seeing no questions, I think that concludes this panel as well as this bill hearing. Thank you guys very much. Colleagues, make sure that you understand Mrs. Joy is waiting to collect all of your money for the committee dinner, unless Delegate Fisher wants to cover us. I think everybody's going to need to go ahead and the committee dinner is next week? Next Thursday, guys, so please. Huh? She needs it by this Friday. Committee dinner, the money for committee dinner. Thank you guys very much. I'll see you guys on the floor. We got a little bit of time to break. Don't be reckless. See you.